We have here Sarah Beebe, who is with Disability Rights of Texas, which is an amazing, magical group of people who level the playing field for our kids. More specifically, what we probably in the last embarrassingly short period of time, 5 to 7 years, realized in my neck of the woods is that kids spend 2/3 of their life at school and not with their parents, not with juvenile probation. So we've got to collaborate. And by collaborate, this commission means take tips and techniques and learn and copy and, sincerest form of flattery. So we're here to receive some great information. But let me just tell you a little bit of background. When youth become involved with the juvenile justice system, they encounter unique hurdles to accessing education services from reentry into the public school system through graduation. Education advocacy is a best practice for serving justice-involved youth that can help improve educational outcomes and reduce recidivism. Sarah Beebe is a supervising attorney at Disability Rights Texas. Her presentation will provide information about the rights of justice-involved youth to be served by public schools and practical steps for a proactive approach to addressing school-related barriers to success. Please welcome Ms. Beebe.
Thank you so much for that introduction. I am so glad to be here with you this morning. And so I'll start with good morning. Good morning. All right. Everybody is here and paying attention. Awesome. Love it. Okay. So my presentation is, I'm going to go back. There we go. Education justice, ensuring educational success for justice-involved youth. And so we have a pretty packed agenda for you today. I'm going to go over a number of different issues. I want to start by talking to you about the program that I operate, because I think that when we're here at this kind of summit and we want to talk about best practices and solutions to addressing our justice-involved youth's needs, it helps to hear about programs that are working. And so first I'll spend a little time talking to you about the program that I operate at Disability Rights Texas, and then we'll get into sort of the meat of our presentation. We'll talk about the school to prison pipeline and school discipline, specifically here in Texas. We'll talk about school reentry for our youth who are coming back from justice facilities and from disciplinary placements. We'll talk really fast about youth with disabilities. I don't feel like I can give you a presentation without at least giving you the rundown of the services that they're entitled to at school. We'll talk about implications for juvenile cases and client representation, and I'll give you some resources. Okay, so away we go. Who here knows of Disability Rights Texas? Who's heard our name? All right, that makes me so happy to see the number of hands raised in this room. I always like to kind of get a feel for who knows us. So if you don't know us, we are the federally designated protection and advocacy organization in the state of Texas for people with disabilities. We are a nonprofit funded organization. We are comprised of lawyers and advocates who provide free legal and advocacy services to people with disabilities. So while I have spent my 14 years at Disability Rights Texas focused exclusively on education, we have a number of other issues that we work on: employment discrimination, transportation discrimination. We do Medicaid fair hearings. We work really hard to ensure people with disabilities who want to live in the community have that opportunity. And our mission is to help people with disabilities understand and exercise their rights under the law, ensuring their full and equal participation in society. So we're like free legal aid for people with disabilities working on civil rights issues, if that makes sense. So it's important to talk about youth with disabilities and education in the juvenile justice context because they face really unique hurdles when it comes to their education. And most research suggests that approximately 70% of youth in the justice system have a disability. I've actually seen research that suggests it could be upwards of 90%. A lot of our youth sort of go fly under the radar, right? Go undiagnosed, unrecognized. And schools often refer kids to the juvenile justice system without identifying their need for special education services, without providing additional behavioral and mental health supports that they need in school. I can't tell you how many times I've been at a conference and had a school person talk to me and say, well, you know, we were just at our wits' end. We didn't know what else to do. So we, made the referral to the juvenile justice system so they could get the help they needed. It breaks my heart when people say that in the school system, because while my colleagues, and I do consider you all colleagues in the juvenile justice world, do have access to programs and resources that can certainly help our kids, so do schools, and they just don't access them often enough. So I like to push back on them and talk to them about what else it is they could be doing to help youth before they take that step of referring them to the justice system. And, too often we find that juvenile system professionals and education advocates are working in silos, right? We don't know enough about what each other is doing. We don't understand the juvenile system well enough as education attorneys. And perhaps you in the juvenile system don't understand well enough, what goes on at school, what our students' rights are, and what really could be being done for them. So the program that we have established at Disability Rights Texas, our Juvenile Probation Education Advocacy Program, really bridges that gap. We established a formal partnership with Harris County Juvenile Probation Department about 8 years ago now. And in that time, we have improved education services for over 2,000 youth. And the probation department took it upon themselves to figure out, is it worth it? The money they're spending on paying us for our services, is it reducing recidivism? Is it improving graduation rates? They did an analysis of our cases, the ones that we had touched and provided direct advocacy for students, and they found that 94% of the youth we were working with did not reoffend within 1 year of release from probation. 94%. We're thrilled with that number, and we believe that our advocacy is meaningful for our students. As was said, our students spend most of their day at school. If things aren't going well at school, they can't possibly be going well elsewhere. So we take very seriously our efforts to ensure that they're getting what they need at school so they can stay in school, graduate, and not come back into the justice system, juvenile or criminal. So we do this by providing tiered advocacy services, meaning everybody who asks for our help gets at least training or technical assistance. We walk folks through, what do you do in this situation where a youth is really struggling? Who do you contact at the school? Here's a letter you can send to the school asking for services. If that's not enough, then we will provide direct advocacy services, and we will go to the school and we will fight for that student's rights. We'll talk to the school and we'll collaborate with them about what would be a better plan for the student to ensure that they're having success. And at the very top of that pyramid, the service we access least of all is legal representation, although we do have lawyers on the team, myself included, and we will file complaints if necessary. And the trainings that we provide them statewide. I often give trainings at the beginning and end of every school year to many different, to juvenile attorneys, to probation departments. And then we also have a school reentry work group, a collaborative of community stakeholders who are invested in ensuring that our youth who are coming back to school from the juvenile justice system or from disciplinary placements have the opportunity to get back in hassle-free and receive the support that they need to be successful there. So we kind of tackle it from all angles. We find that it's not enough just to take the individual cases. We have to be looking at the systemic barriers and addressing those as well. So it's a comprehensive approach where we really try to address all of our youth's needs. So that's the program. I just wanted you to know the place where I come from, a little bit more about me and what I do. I've been working exclusively with justice-involved youth for 8 years, and so have my team members, and we're just so privileged and happy to do that because we know that our youth need a lot of support. Their needs are complex, and so we love what we do. Okay, let's talk about the school-to-prison pipeline. So what I want you all to know, I know that most often when we talk about the school to prison pipeline, we're talking about the school making a referral to law enforcement, kind of as I'd mentioned earlier, right? But what I want everyone to understand is that here in Texas, our system is actually quite cyclical. What I mean is that, yes, schools make referrals to law enforcement, and then from there, they may become involved with the juvenile justice system, but once a youth touches the juvenile justice system, even if the referral is not made by the school becomes aware of that interaction and can then punish our students for it, whether it happened at school or not. I get that question all the time, and it breaks my heart to have to be the bearer of bad news to say, yeah, it doesn't matter that it didn't happen at school. the school still has the right to punish this kid for it. So it just goes round and round, right? In and out and round and round. So want to explain and make sure when we talk about certain terms, we're talking about discipline at school, what we're talking about. And so there are 4 very common forms of discipline. One is in-school suspension, where the student would remain at school, but in a separate setting and be there for a certain number of days, sometimes just a few, sometimes very many. Then there's out-of-school suspension, where school districts remove students for only 3 days at a time. That is the max for which they can remove a student consecutively. And then there is removal to disciplinary alternative education programs. And these are very often operated by the school district itself, but it's a separate campus. And they'll send the student there again for a specified number of days. Then there is also expulsion or removal to juvenile justice alternative education programs. Now, these programs only exist in counties that have a population of 125,000 or more. So for those of you who may work in more rural areas, you may not have JJAPs. But for those who do work in areas with a county that size, 125,000 or more, you should have a JJP, and you may find that students are sent there. So school discipline by the numbers. Approximately 60% of Texas students will be suspended or expelled at some point in their educational career. 60%, y'all. That's a lot of kids. So students who are suspended or expelled are twice as likely to repeat their grade, and with the same, if we're controlling for all the same characteristics, right? So just kind of same kids, same factors. If they have been suspended or expelled, they are likely to repeat the grade. When they're suspended or expelled for a discretionary violation, meaning the school didn't have to, but they chose to, they're nearly 3 times as likely to come in contact with the juvenile justice system the following year. And juvenile incarceration rates have actually dropped by 40%, but what we've seen is that in reaction to the justice system saying, no, this isn't the way we want to go, we're going to keep kids out of the system, schools have responded in kind with more excessive discipline. And students with disabilities are twice as likely to receive an out-of-school suspension than students without disabilities. So our students with disabilities are disproportionately at risk for discipline, which then makes them disproportionately at risk for justice involvement. So let's talk about school discipline procedures, because I think sometimes this is a mystery. I think often when we're working with parents, the school kind of railroads them a little bit when it comes to discipline, and our parents feel like they don't have any rights at all. Well, I'm here to tell you they do have some rights. And so as I mentioned before, whenever the school district wants to suspend a student out of school, they can only do so for 3 consecutive days. Now, can they suspend a kid for 3 days, bring them back, suspend them for 3 more, bring them back, yes, they can. Yes, they can. But that's a red flag. Something's not right. We shouldn't have the kid come back for a minute and then be kicked right back out. So that's a big red flag that something more needs to be done in that situation than discipline. But in all disciplinary removals, no matter whether they are discretionary at the school's decision or if they're considered mandatory under the law, the school administrator who's issuing the discipline has to consider certain factors. They must look at self-defense. If that applies. They must look at intent. You know, a lot of our kids do something and it really goes the wrong way. And they didn't mean for it to go that way, but it just did. You know, they're kids, they don't have the best judgment. And so the administrator really has to look at was what happened, what this kid intended to do. They also have to look at the student's disciplinary history and their disability. When we talk about disability in this context, though, we're really talking about whether the student had the intellectual or cognitive capacity to understand the right and wrongfulness of their actions. So it's not any disability, it's really more about did they get what they were doing was wrong. Then they also have to look at foster care involvement and homelessness. And so the student and the parent have a right to a disciplinary conference where all of this will be discussed. The student has the right to tell their side of the story. Sometimes we see that happening in a phone call. And I can't tell you how many parents I talked to who just said, you know, they asked me to come in and talk to them about it, but what was there to talk about? No, go to the meeting. Go to the meeting. That is your chance to say to the school, hey, this is what really happened, or this is what's been going on with my student. Because while they have to consider all of those factors, they can consider any factors. So there may be really relevant information that a parent has about how the student woke up that morning, that they had a bad night the night before, there's trauma going on in their lives that needs to be shared with the school. So if you're hearing a parent say, oh, I just didn't go to the discipline, or they called me and I just didn't bother. No, tell them, encourage them, go to that meeting. And so, let's see. Oh, so it gets back to what I was saying before about how students can be punished even for offenses that occur outside of school. I get this question all the time. For our students who are alleged to have committed a Title V felony against the person, or assault, sexual assaults, even felony level terroristic threats, and aggravated robbery. That's not a Title V felony, of course, but it's carved out in the Texas Education Code as one of the offenses for which the school district can send a student to a disciplinary, a DAEP or a JJAP, either until they graduate high school. We'll let that sink in. Until they graduate high school, no matter what age this happened. The charge is dismissed or reduced to a misdemeanor, or the student completes the term of the placement. And most often, the term of the placement is a minimum of 180 days. That's a whole school year. I say this, and I want it to sink in, because this applies to students at the point at which they are arrested. It does not matter if they've been fully adjudicated. It does not matter where they are in the process. Schools do not care. They have the right to make this decision just based on the fact that the DA's office has informed them that the student was arrested and the charge was this level. It's so tough on our babies, y'all. It's so hard on them to know that the wheels of justice are still turning, but they're going to be sent to this disciplinary placement for a year. I've had kids who maintained their innocence the entire time they were at the JJAP, and no matter what we said to the district, they didn't care. They had the right to send them, and so they did. And turns out, down the road, sure enough, that case was non-suited, and it was like it never happened in the justice system. But for school purposes, that kid's life was forever changed. And I know maybe that sounds traumatic, but or dramatic, but think about it. You as a kid, right? Sitting at a juvenile justice alternative education program far away from your school district for all that time, knowing I didn't really actually do anything wrong. Or the thing that I was charged with, that was an extreme charge, but then it got reduced because my involvement in it wasn't that serious. So I say that to y'all to understand how much power and discretion schools have to punish our kids when they are justice involved. It's upsetting for a lot of us in the education world and for our kids and families. The other sort of consequence for our youth who then spend time in disciplinary programs or who are coming out of juvenile facilities is that then they leave those programs and they come back to their home campus and they're often told, no, you can't enroll, which is really heartbreaking for our youth, right? Time for my fresh start. I'm back in the community. I'm going to go back to school. This time's going to be different. Oh, you won't let me in? What? So over 2/3 of our youth don't return to school following release from a juvenile facility. 2/3. That number is stark. And so we have to work very hard to get our kids back into school. So I wanted y'all to know about some of the issues that arise for our kids when they come back. Very often, they're legally entitled to enroll in the school, but our registrars may come up with some reasons why they can't. Often it has to do with documents that the student may or may not have, even though generally speaking, students can enroll in school without most of the documents that are required. They can have a provisional enrollment and then they can fix all the documents that are needed down the road. Also, what we see is that youth who are coming out of juvenile facilities in particular, schools sort of act like they haven't been in school that whole time. And so don't award them credit for the work that they did while they were there. Most of our kids, statistically speaking, when they're justice involved, are already behind academically. So when they come back from a juvenile facility and they're going back to school middle of the semester, their counselor may just sort of scratch their heads and say, well, you didn't complete the semester at the juvenile facility, or not even acknowledge that they were in school at that time. And so not award them credit, and the student has to repeat that grade or those credits all over again. It's so tough on them, y'all. It's so hard for them to come back to school. So there is now a law in Texas as of 4 years ago, and that school reentry work group that I mentioned to you earlier is responsible for helping pass this law because we saw the need for our schools to do more to catch our students as they're coming back. And so this law requires that within 5 days of the student's release, the school district has to put in a transition plan. And that plan needs to talk about the best educational placement for that student. And what I mean is really like, should they go back to just a regular class schedule? Do they need credit recovery? Do they need, some other programming? Where do they need to be? And then also, what support do they need? Do they need mental health supports? Should we evaluate them for special education services? Do they need academic support? And put it all down in writing and actually follow up on it and check on it and make sure it's working on a regular basis. Now, as of this past legislative session, school districts are actually required to tell parents about their right to request an evaluation for special education services at the time that students enter a DAP, a disciplinary alternative education program, and on their way out. I think this is the state's way of sort of remedying some past issues we've had that I'll get to shortly about not evaluating students for services enough. So it's good news. Parents are going to get more information about when their students, their rights to have their students evaluated for services. Okay, now we're going to talk about youth with disabilities. So I'm going to give you the fastest rundown ever of 504 versus special education services. I just feel like I'd be doing you a disservice if we just didn't talk about the differences between them briefly. But the truth is, I could stand up here all day and we could talk about the differences between these two laws that support and protect our students at school. There are many programs out there that will even have full conferences where we just talk about this. So, really fast. Section 504 of the Rehabilitation Act is an anti-discrimination law. It protects our students from being discriminated against because of their disability and makes sure that they are getting at least basic accommodations in the classroom so that they can be successful. What do I mean by accommodations? This student needs to sit at the front of the classroom or else they'll get off track. This student needs to have extra time on this assignment because they need a little extra time to process what it is they're doing. This student needs to have shortened assignments. Instead of those 20 math problems, they're only going to do 10. Those are some basic accommodations. And so the child, in order to qualify for 504, the child has to have a diagnosed disability by an outside medical professional, and because of that, need services at school. And really, that just means that it affects a major life activity. In school, we just generally say learning, but it can be anything, walking, talking, really anything that affects a major life activity. And so schools are, and it follows the youth. So schools are required to provide this service when a student has that diagnosed disability and needs accommodations, but it can follow them outside of school into college. Could be used to talk about accommodations for vocational training, for certain tests the student might take later in life. And so that's 504. It's pretty basic. Special education, on the other hand, is quite different. There are 13 eligibility categories, and the student has to be evaluated in order to qualify under one of those eligibility categories. They actually don't have to have a medical diagnosis. You can just say, I really think my kid has a learning disability, and ask the school to evaluate them, and they could say, yeah, okay, we'll evaluate you, and we'll see if you qualify. Under that plan, they have to reevaluate the student at least every 3 years. There is a gigantic comprehensive document called an individualized education program. Sometimes it could be 50 pages long that lays out all of the services the student is going to receive. It can include accommodations, but it can also include things like speech therapy, counseling, behavioral support, you name it. Whatever that kid needs, they need to get under that plan. And so it is far more robust, and there are a lot more protections for students under special education services. And it only lasts until a student graduates from high school. So it does not follow them to college like 504 can. It is over once the student is done with regular school. But there are some overlaps, and so it has both plans. 504 plan or IEP have to be reviewed annually, and they are both provided at no cost to the family, and both can provide accommodations, and parents have to provide consent to the services. There's no point at which a school district can put these services in place without the parent saying, yes, I would like you to do that. And if the parent decides down the road they don't want the services anymore, they can always remove that consent. So that was the real quick and dirty on special ed versus 504. Okay, so on the screen now, I have for you a Houston Chronicle article that was done several years ago now, where they blew wide open a scandal, if you will, from the Texas Education Agency, where they had put a cap on special education services in place starting from about 2004. And I recognize that this may be that line. That line for Texas is really difficult to see, and I apologize for that. I need a better visual. But starting in 2004, TEA said, hey, only 8.5% of students in your district can be eligible for special education services. It does not matter how large your district is, or that maybe there are other students, more than 8.5%, that need services. You shall not provide any services to students more than beyond 8.5%. Which makes no sense for districts like Houston ISD, for instance, which is the largest district in the state and is urban, and we find that disability occurrence is greater in urban areas. So sure enough, all the districts hurried up and got themselves in compliance. And if you can see that line, you'll see that starting in 2004, it dips well below the national average. And within about a decade, all the school districts got themselves to that 8.5%. If they didn't, they got a corrective action plan from TEA, making them get that number down. And so now we are in the process of undoing all of this. Because after this story came out in the Houston Chronicle, the federal government got involved and said, hey, you can't do that. It's an individualized process. If a kid needs services, they need services. You can't cap it. And so we are now in the process of undoing that. At one point, I'll just mention, Houston ISD got itself down to 7.9% of eligibility, which is outrageous. It should have been more like 15. So only half the students in that district were receiving the services that they should have. So in the juvenile system, I want you all to know this because I think it's really relevant, because I think if you're working with justice-involved youth, you are working with the victims of this every single day. I know I see it in my work every single day. The youth who didn't get evaluated for services and have suffered because of it, right? Who are super far behind, who have behavioral problems that were never addressed. So I think it's really important to know why we're in that spot. And it actually comes from an organized, concerted effort from the state to get the numbers down in school districts. Our organization, Disability Rights Texas, got very involved in investigating this ourselves. And actually, we were the ones who passed along the story to the Houston Chronicle. And when we asked TEA, why 8.5%? Like, is that research-based? Where'd you come up with that? They just sort of said, well, you can't satisfy everyone. 8.5 sounded good to us. And we were like, okay, y'all, so no, that isn't right, doesn't make sense. And so now, fortunately, we do see districts getting their numbers up where they need to be, but it is quite a process. And so in order for a student to be evaluated for special education services, it takes a really long time. And we have a massive shortage of evaluators. So what I want to hit home for you is that if you're working with a youth who you think may need services at schools, don't wait. Tell their family to request an evaluation for services, because as soon as they do that, and it should always be in writing, as soon as they do that, the school district has 15 school days to talk about whether or not they're going to evaluate that student or not. They don't have to evaluate, but in most situations, they generally say, yes, we will do that, we will evaluate. But if you think about 15 school days, that is 3 solid weeks of school for them to just make a decision. Once they've made the decision and they say yes, they need to get consent signed by the parent to do the evaluation. And that can take a minute too, depends on the parent's availability, that kind of thing. And so from there, once the parent signs consent, the school has 45 school days to complete an evaluation. That's a really long time because schools have holidays. Students can be absent. It's a really, it doesn't sound like it when you say 45 school days is a really long time. And then once the evaluation is completed, they have 30 calendar days to sit down and have a meeting and talk about what were the results of that evaluation. Does the student qualify? If they do, what services are we going to put in place, and actually start to implement the plan. So this is a long process, is really what I want to emphasize to you today. So if you are working with a youth who you think needs to be evaluated, have them ask the school to evaluate their child as soon as possible. Now, we have on our website a sample evaluation letter that you can submit, but I'll tell y'all, it's as simple as having the parent email their school principal and simply say, I would like my student evaluated for special education services, please. That's it. That's all they have to do. That is enough to trigger these timelines to get the process going. Okay, so now we've talked a little bit about some of the big issues, the discipline issues, the disability service issues, just getting evaluated, qualifying for services that really impact our justice-involved youth. Those are some of the biggest issues that we see for our kids, getting back into school after they have been justice-involved. And so now I want to talk a little bit of strategy for you all in the justice system. So using evaluations. When possible, juvenile defense attorneys should provide special education attorneys with information to advance their claims for the school, or they can use. So what happens is that if there is an evaluation that has been done by the juvenile system, a psychological evaluation, it really helps us to know that. Now, I'm not saying release that evaluation to the school. Absolutely not. Under no circumstances, do not do that, because there's a whole lot of sensitive and confidential information in there that the school should never, ever, ever have their hands on. But as an attorney who works in the education system, when I get my hands on a psychological evaluation that's been done in the justice system, it helps me tremendously to get a better sense of what's going on with that youth. And if that youth has been diagnosed with certain disabilities, what I'll then do is go to the psychologist and say, hey, can you just give me a little letter? Just a quick little letter that says, I, so-and-so psychologist, evaluated youth on XYZ date. I diagnosed them under the DSM-5 with these diagnoses. I do think they should receive supports at schools, maybe give them 504 services. Thank you very much. Quick, easy. But if I know what the psychological evaluation says, that may be an easy way for me to go to the school and get at least some basic accommodations in place for that student quickly. Similarly, if that student has been evaluated for special education services, that can be really helpful to you if you're a juvenile defense attorney or a judge to know, hey, what did the school say? Understand that the school's evaluation is strictly for educational purposes. It is not a medical evaluation at all. It is strictly done to see, does the student qualify for services? Still really useful information. And the IEP will explain and share, kind of what services the school has put in place. And if the incident happened at school, I think it could be really interesting if you're a juvenile defense attorney or a judge to see what was it the school said they were going to be doing to support this student. And in this incident, did they do that? Did they actually follow this plan? And so, speaking of that, I wanted to share with you all the special disciplinary protections that our students with disabilities have, because I think this comes in and is really relevant where the incident happened at school. The incident leading to the justice involvement happened at school. Because students with disabilities are entitled to a special disciplinary process. I mentioned earlier the procedures for having a conference, having a meeting with the school administrator to consider certain factors. That's more the, did they do it? And if they did, how bad was it? This conversation also is an extra step that happens for our students who have 504 or special education services, where the school district sits down and talks about, okay, assuming the kid did it, we're not going to talk about whether they did it or not, just assuming they did it, was it disability-related behavior? If yes, we don't send you to the disciplinary program that we're proposing to send you to. Or did we fail to implement that plan I just talked about, the behavioral plan we have in place for you? Did we as the school fail to do that? Again, if yes, no disciplinary placement for you. There are exceptions to this, unfortunately, or of course, and so those exceptions have to do with when weapons, drugs, or serious bodily injury is involved in the incident. If that is the case, the school district can still send the student to the disciplinary program for 45 days, even if they agree it was a disability-related behavior or that they failed to implement the student's plan in some way. But I think this is a really important process to know about. Too, because it applies to students who are not yet eligible for special education services. What? Yes. So if the school is on notice that this is a kid who probably needs special education services, they still have to hold that manifestation determination review meeting, that special disciplinary meeting that I just described. And, a lot of you, I'm sure, most of you are lawyers. If you're not, notice is a real term of art in this situation. It has a very specific meaning. It means when the youth's parent or guardian has expressed concern in writing to a school administrator or a teacher that they believe their child needs special education services. So it doesn't have to go so far as to be that specific, hey, I want you to evaluate, just like a, hey, I think my kid is struggling and may need to be evaluated. That would be enough for notice. Yeah, the youth's parent or guardian has requested an evaluation. They've actually put it in writing and said, hey, I do want you to evaluate. Or the youth's teacher or other district staff member has expressed concern about the youth's pattern of behavior to a special education director or other district level staff. That's notice. So if any of those apply, the school district still has to do that special manifestation determination review meeting. That's really critical. That's another reason it's so important to get our kids in the process of getting evaluated, because it automatically and immediately kicks in those special disciplinary protections for them. And so how does the MDR help in the youth's juvenile case? Well, if there is a special education attorney or advocate involved in the case and they've assisted the family with the MDR and the school district has said, yeah, this was disability related behavior, or hey, yeah, we did fail to implement the IEP. I'll tell you that second one is a lot less common. They don't usually generally admit that they didn't implement the IEP. Sometimes they do. More often than not, if they agree that the student shouldn't go to a disciplinary placement, it's because they recognize and acknowledge that the student's disability played a part in the incident. If that is the case, that's really useful information to share with the court, right? To say, hey, this happened at school. Even the school acknowledges that this was something that happened because of the youth's disability or something they failed to do. They're not sending him to the disciplinary placement. Maybe that means we should consider more lenient juvenile consequences for this kid, right? So really useful information to share. That's why it's so great to work together. We can help each other with the juvenile case and with the school case. But when we work together, we always have to understand our different representation, right? And so for juvenile attorneys, of course, the youth is your client. For special education attorneys, it's a little more complicated than that. We absolutely care about and take into consideration the youth's wishes. However, under education law, the parent is the decision maker. So we have to sign up the parent as our client and treat them as sort of our main client. But of course, we pay very close attention to whether or not the student's wishes and the parent's wishes are in conflict with one another. And so we work really hard to make sure that we avoid those conflicts as much as possible. But so we're representing, education attorneys are representing the parents mainly, and y'all represent the youth. And so it's important to know that too, especially for purposes of maintaining confidentiality. It's so great to work together, but you got to get releases signed right so we can share information back and forth, and just be careful about, you know, what we're sharing back and forth with one another. And so it's best to obtain that express written consent to share that information and case strategy with one another. These are some of the resources that we have on our website that I hope you'll check out and access. So we have information about how to request that initial evaluation, and we have an interactive disciplinary guide. This is one of my favorite resources on our website because you can go to this interactive disciplinary guide and click through to figure out what should be happening discipline-wise. You know, so it'll ask you a bunch of questions, and as you answer those questions, it'll take you to the next step. So if you answer yes, it's this, no, it's that, and so it's a really neat guide. We also have a school reentry toolkit. So if you have a youth who's having a really hard time getting back into school, this toolkit will give you all the information you need about how to work with the school to get that kid back in. It kind of give you the common excuses that schools might use to keep a kid out of school, and then how you can push back and say, hey, no, I know that that's not actually right. This kid does have the right to enroll in school. Please enroll them now. It also talks about the transition planning that is required for youth who are returning from juvenile facilities or from disciplinary placements. And so is a really comprehensive guide to help walk you through that process. I cannot believe it. I have 5 minutes left. Who has questions? 5 minutes left. Yes.
Is it too late if our children get to the juvenile system, which is roughly 14, 15, 16, if they haven't had dyslexia intervention?
No, I would not say it is too late for dyslexia intervention. What I will tell you about that is it's tough at that age, right? It will be a lot of work to overcome, not overcome, but to try to find the right accommodations for that student, the right reading intervention. And what we find is that schools often do not have dyslexia intervention or reading intervention services at that level. at the middle and high school level. So sometimes what's the most challenging is just getting the school district to take the resources they've dedicated to our elementary students and put them with our older students who have gotten looked over, who've been missed, right? Great question, though. Yeah, so it's not too late. It's just a little more challenging.
Thank you. If you have questions, you can go to the microphones in the middle of the room. They're 1, 2, 3 in the middle. I had another question, if I'm going to be the needy one here. So when we have a school district who expels their child to JJAEP, after an incidence of juvenile justice on campus, how do we implement your services? How do we connect them with you all?
Yes, that's such a great question. So let me talk about sort of the two different programs we have, because I think that's a great thing to discuss and sort of clarify. So the program that I operate, the Juvenile Probation Education Advocacy Program, is focused primarily with Harris County, because it's Harris County Juvenile Probation Department who is contracted for our services so that we can support their youth exclusively with this smaller program. We're having conversations with other probation departments to expand our services elsewhere, and we hope to do that because we think that our services could be beneficial to everyone across the state, to all of our justice-involved youth. However, there is a statewide education team at Disability Rights Texas, and so at any point, if you think to yourself, gosh, I really think this student is not getting the services that they need at school, you're always welcome to refer them to us. There are some qualifications for our services, and so they have to have a disability, or at least acknowledge that they have a disability. Unfortunately, we work with families a lot who have a hard time with the label, right? And I do understand that, but in order to receive our services, we have to have agreement that there is a disability at play here. And so if the student has been placed by the school district for an on-campus, especially an on-campus offense to the Juvenile Justice Alternative Education Program, if they have a disability and they're receiving services or not, quite frankly, we would potentially take that case, because one of the priorities that our board of directors has designated for the education team is to work on exclusive and excessive discipline for our students with disabilities. So that is a case that we could take. And I guess I don't have, so we have an intake number, 800-252-9108. I'll say it again, 800-252-9108. You can always look on the Disability Rights Texas website as well, and we do have an online intake form that parents can fill out. I get questions a lot too about, as a provider or as somebody who's working with a family, can I fill out the online intake form? Yes, but we got to talk to the parent. The parent has to want our services, right? So, yeah, the parent has to be on board. If you apply and we talk to them and they say no thanks, there's not a lot we can do. So good to work with the parent and talk to them about, hey, I really think this service could help you. You know, I'll help you fill out the form or make the phone call. But we do have a fantastic intake specialist who is fluent in Spanish as well. So no fear, if you have a Spanish-speaking parent who calls us, they'll be able to talk to the parent and get them set up with our services. So it's like two different programs. We both do education work, mine exclusively with justice-involved youth, primarily in Harris County. But that doesn't mean that you can't reach out to me. I would love for you, if you have questions, email me, contact me and say, hey, how can we get a program established in our county? Happy to talk to you about that. Or really any other issues that are coming up for your justice-involved youth. Try to provide some sort of technical assistance with the issue. Yes. Thank you all. All right.
Thank you so much.
Thank you. Thank you.